Have you ever lost something at the dry cleaner? Maybe a button or a single sock. It's annoying, but for one Washington, D.C. judge, it escalated into a multi-million-dollar legal battle. Our story begins in May 2005, when Royale, Pearson Jr., an administrative law judge, took a pair of gray pants with red pinstripes to custom cleaners. He claimed they were Armani designer pants, worth over $1,000. When he went to pick them up, he stated the cleaners had lost them. The dry cleaner, Ji-Nam Chung, a Korean immigrant, and his family searched diligently but couldn't locate the specific trousers. This seemingly minor mishap, a common occurrence in the service industry, would soon spiral into one of the most talked about and bizarre lawsuits in American history. But the pants weren't actually lost, at least not in the way Pearson claimed, and the plot quickly thickened from here. Pearson eventually located his pants, but he claimed they were not his original pair and that they had been returned without the promised alterations. More significantly, he alleged the cleaners had lost the pants, then found them but damaged them during cleaning. He demanded $1,000 for a new pair of pants, a figure the dry cleaner disputed, offering instead a $100 settlement based on their posted liability limits. Pearson scoffed at this. His demands quickly escalated, moving from a replacement cost to a complex list of damages. He argued that the loss of his pants and the subsequent dispute caused him mental distress, inconvenience, and forced him to find another dry cleaner. This wasn't just about a pair of pants anymore. It was about principle, at least in Pearson's mind. But how did mental distress over pants turn into millions? Here's where the numbers get truly wild. Pearson's initial demands quickly ballooned. He wasn't just asking for the value of the pants. He claimed the dry cleaner violated the District of Columbia's Consumer Protection Procedures Act. This act allows for specific damages, $1,500 per violation, plus attorney fees and punitive damages. Pearson meticulously calculated 12 distinct violations, including failing to warn him of their satisfaction guaranteed promise, violating a written contract, and more. He initially sought $67 million, later reducing it to $54 million. This figure included $15,000 for the pants themselves, $2 million for emotional distress, and a staggering $50 million for violating the Consumer Protection Act and causing him significant inconvenience. The dry cleaner, a small, family-owned business, was aghast. They simply could not fathom such a sum, let alone how a pair of trousers could possibly justify it. The sheer scale of the demand alone made headlines. The case, Royale, Pearson Jr. v. Custom Cleaners, went to trial in June 2007. Pearson, representing himself, presented his arguments with meticulous detail, but often to the bewilderment of the court and the media. He brought in charts and graphs, attempting to prove the dry cleaner's satisfaction guaranteed sign was misleading and that their practices were deceptive. The Chung family, meanwhile, maintained their innocence and bewilderment. They offered a settlement of $12,000 at one point, hoping to make the case go away, but Pearson refused. He was convinced he had a solid case and was determined to see it through, even if it meant bankrupting a small business. The judge presiding over the case, Judge Judith Bartnoff, struggled to maintain order and decorum as Pearson's arguments grew increasingly convoluted. But what exactly was the legal basis for his outlandish claims? Pearson's legal strategy hinged on several key points. First, he argued that custom cleaners had a satisfaction guaranteed sign in their window, which he claimed constituted an unconditional promise. When he wasn't satisfied, he argued they violated this promise. Second, he claimed the cleaners lost his pants and then returned a different, inferior pair, breaching their contract. Third, and most controversially, he applied the District of Columbia Consumer Protection Procedures Act to every perceived transgression, accumulating a massive penalty. He argued that each day his pants were lost, or each time the satisfaction guaranteed sign was displayed, it counted as a separate violation. This interpretation, Multiplying minor infractions by days or instances is what allowed him to reach the astronomical $54 million figure. However, the law typically doesn't work that way, especially for minor consumer disputes. The court had to decide if his interpretation held water. After a 2-day trial, Judge Bartnoff delivered her verdict. She ruled in favor of custom cleaners, dismissing Pearson's claims. The judge found that Pearson had failed to prove the pants were lost, damaged, or that the satisfaction guaranteed sign was deceptive in the way he alleged. She stated that while Pearson was genuinely upset, his claims were not supported by the evidence or by a reasonable interpretation of the law. The Chung family wept with relief. The judge also ordered Pearson to pay the court costs, a small fraction of what he had demanded, but a symbolic victory for the cleaners. This wasn't the end of the story, though. Pearson, undeterred, immediately announced his intention to appeal the decision. He believed the judicial system had failed him, and he was determined to prove his point. But how often do appeals actually succeed in cases like this? Pearson, true to his word, appealed the decision. His case went before the District of Columbia Court of Appeals. He argued that the trial judge had made several errors, including misinterpreting the consumer protection law and failing to give proper weight to his evidence. The appellate court, however, was not swayed. In a unanimous decision, they upheld the lower court's ruling, finding no legal error in Judge Bartnoff's judgment. The appellate judges agreed that Pearson's interpretation of the Consumer Protection Procedures Act was overly expansive and not how the law was intended to be applied. They reiterated that while consumer protection is important, it cannot be used to justify absurdly disproportionate damages for minor grievances. This ruling effectively put an end to Pearson's pursuit of the $54 million. But the case left a lasting impression on the legal community and the public. So what was the real cost of this frivolous lawsuit? While Roy Pearson didn't win $54 million, the cost to the Chung family was substantial. They spent tens of thousands of dollars on legal fees defending themselves against a clearly baseless claim. This financial burden, coupled with the immense stress and emotional toll of being dragged through a high-profile lawsuit, nearly ruined their small business. For many small business owners, defending against such a suit can be devastating, even if they ultimately win. Beyond the direct financial costs, there's the broader societal impact. Frivolous lawsuits clog up court systems, diverting resources from legitimate cases and increasing costs for all taxpayers. They also contribute to a perception that the legal system is easily exploited, eroding public trust. But there's a common myth about these cases that needs to be debunked. A common myth perpetuated by cases like Pearson's is that anyone can sue for millions over minor issues and win. This is simply not true. While the initial demand for $54 million was shocking, the legal system ultimately rejected it. Courts and judges have mechanisms to dismiss frivolous lawsuits, and appellate courts review decisions to ensure they align with legal precedent and common sense. The Pearson case, far from being a blueprint for easy riches, actually serves as a cautionary tale. It demonstrates that while individuals have the right to represent themselves and to pursue claims, there are limits. Judges and juries are not easily swayed by hyperinflated damage claims without clear, demonstrable harm. Understanding this distinction is crucial to grasping how the legal system actually functions and why most such attempts fail spectacularly. The District of Columbia Consumer Protection Procedures Act, like similar laws across the U.S., was created to protect consumers from genuine fraud, deceptive trade practices, and significant harm caused by businesses. It provides avenues for redress when consumers are truly wronged. However, it was never intended to be a tool for individuals to seek astronomical sums for minor inconveniences or perceived slights, especially when no actual damage or loss can be proven. The law aims to balance consumer protection with fairness to businesses, ensuring that both parties have reasonable expectations and recourse. Pearson's interpretation pushed the boundaries of this intent to an absurd degree, highlighting the importance of judicial interpretation in applying laws appropriately. So, how do judges prevent these kinds of situations from completely derailing the courts? While Pearson was never formally sanctioned or disbarred over this case, the courts do have powers to address frivolous litigation. Judges can dismiss cases that lack merit, issue sanctions against attorneys, and sometimes self-represented litigants who file baseless claims and order the losing party to pay the other side's legal fees. Rule 11 of the Federal Rules of Civil Procedure, for example, allows courts to impose sanctions on parties or attorneys who present pleadings, motions, or other papers to the court for an improper purpose, such as to harass or cause unnecessary delay or needless increase in the cost of litigation. These mechanisms are vital for maintaining the integrity of the legal system and preventing its abuse. The Pearson case, while extreme, ultimately reinforced these checks and balances, proving that the system, while sometimes slow, does correct itself. The 54 million pants lawsuit offers several key takeaways. For consumers, it's a reminder that while you have rights, those rights are tied to demonstrable harm and reasonable expectations. For businesses, it highlights the importance of clear policies, good customer service, and understanding liability limits. And for the legal system, it underscored the need for judges to act as gatekeepers against frivolous litigation, protecting both parties and the public interest. While the case was widely mocked, it also sparked important conversations about tort reform and the responsibilities of litigants. It demonstrated that even in America's litigious society, there are limits to what can be claimed and won in a court of law. So what's the single most important lesson from this bizarre legal saga? The core lesson from the $54 million pants lawsuit is that while everyone has the right to pursue justice, the legal system is ultimately designed to address genuine harm with proportionate remedies. Exaggerated claims, lacking factual or legal basis, will ultimately fail, often at great cost to the claimant and the accused. It's a testament to the checks and balances within our judiciary that such an outlandish demand was rejected, reaffirming that common sense and legal precedents still prevail. If you found this deep dive into America's most ridiculous lawsuit insightful, please consider subscribing for more true legal cases and courtroom stories.